Judica County is brought to you by Whitaker and Hamer, attorneys and counselors at law, your law firm for life.
Welcome back into Judica County Radio, hosted by Josh Whitaker and Joe Hamer. And the power behind this program, where you can find Josh and Joe, they're the managing partners at Whitaker and Hamer Law Firm. They're practicing attorneys here in the great state of North Carolina. They have offices located in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, Gastonia, and in Morehead City. If you've got a legal situation you're facing, you've got questions, you need some answers, you can always call Whitaker and Hamer, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly, what the call's about, and an attorney with Whitaker and Hamer will be in touch. And as always, you can email your questions to the show, info@judicacounty.com. We'll answer them on a future program. So we have another attorney joining us on the program. Josh, who we got?
All right. So if you've been a regular listener of our show, you know and are already familiar with Cassandra Nicholas, but she is our attorney stationed out of the Morehead City office who deals with estate administration and probate across the state of North Carolina.
But we bring Cassandra on to talk to us about a lot of different things. Today, Cassandra is here to talk about estate administration, probate. Those words kind of go together, but basically you're dead and hopefully someone you've named and planned, is taking care of your affairs, taking care of your estate, taking care of your assets because you're no longer here. And me and Joseph, we spend a lot of time talking about planning ahead of time, using your attorney to plan ahead of time to avoid probate, right? We're going to try to avoid the whole process to the extent that we can, to try to keep your information private, keep your heirs or your fiduciaries from having to go downtown and deal with a clerk, deal with a judge, keep things moving along. And Cassandra, in that vein, I was going to talk to you kind of about what estate administration looks like when you can't avoid it, right? So you're usually only involved if we can't avoid. And we just spent some time talking with Ashley about trust and planning to kind of keep things out of probate. But let's just say you don't do anything, you never plan. And you die. What's that going to look like?
So absolutely want to funnel people to Ashley. If you're not already in a situation where you need estate administration, please do your estate planning. Trusts are an excellent tool to be able to avoid estate administration entirely. If you're not using a trust or not causing assets to be automatically transferred to your intended recipients by some other means, either as naming them as beneficiaries on specific assets, pay on death beneficiaries on bank accounts, putting folks on vehicles with you as joint with right of survivorship, so that those automatically transfer just as a function of generally a contract. If that's not the case, then there are two camps when you get to me. For estate administration. There are folks who did estate planning and have a will and everything, but still need estate administration because there are assets that did not automatically transfer by some other means. So you can die testate with a will, with assets that the clerk needs to assign, award to your intended recipients, or you get stuck with the state's default rules, and that's dying intestate without a will. And there's nothing inherently wrong with that. The lawmakers did think, long and hard about how to come up with the schemes of intestacy and how heirs would inherit. But those default rules aren't necessarily what everyone wants. And understanding what those default rules are is important in your estate planning or in considering what happens. A lot of folks don't realize, they think if they are married to someone, that the default rule must be that their spouse gets everything when they pass. But that's not the case. The intestacy statute, if you have a spouse and children, your assets are split between your spouse and children. So if you want your spouse to have everything and you don't want it to be split with your children automatically. You want your spouse to have, the authority to do what they want with those assets. That needs to be done through estate planning rather than allowing just the default rules to exist.
Yeah, that's one of those nightmare situations that we unfortunately see. Everybody thinks, depends on how old you are, how I'm in my late 40s now, so surely I'll make it to my 70s, right? And people in their 60s, surely I'll make it to
I hope you do.
Thank you, me too. But you always think you've got more time, and maybe hopefully you do. But we run in that situation where someone dies way too early, So we've got the situations where the 40-year-old father of 3 has a heart attack and passes away, and hasn't done any estate planning because that's young. Estate planning is hard to think about. And like you said, if the house isn't owned correctly, we've had a situation where a spouse has inherited with underage kids and trying to get that house sold or dealt with when one of the owners is your 4-year-old son is challenging, to say the least, right?
Oh, absolutely. Because then we're also dealing with not just the intestacy, not just the estate administration. You also then need to deal with a guardianship in order to the courts are interested in protecting the assets of minors. So a parent can't just automatically make decisions about real estate that a minor inherited for them. You need to have permission from the courts to do so. And, that is a lot of work, time, attorney expense, court fee expenses, mandatory hearings for guardianships to get a guardian assigned. So especially when there are minor children involved, it's important to do the estate planning on the front end because we are here and we're happy to help with all of those, but we want people to be aware that it's definitely going to be added time and expense when you haven't avoided those on the front end.
And it's just like anything else. Me and Joe have talked today about business planning. You can do a lot of planning with your operating agreement, with your business assets, so that when someone passes away or when there's a disagreement with a partner, you've already kind of planned out what's going to happen, and it doesn't necessarily have to become something that's litigated, right? Our big theme today is things that the courts have to be involved with, things that have to be public versus things that you can keep private and plan around. And so we've talked about that as, in business planning. We've talked about we've talked about family law planning. If prenups, separations, agreements, planning before separation. There's a lot of stuff you can plan and agree to and keep private, rather than putting it on display in the kind of public arena. And we've talked to Ashley about estate planning to try to avoid probate. But here, our example, our 42-year-old who passed away way too early without any notice. He left his family with a lot of trouble because he hadn't planned, and that's no knock against him. That's the way these things go. But to the extent that you can stop what you're doing and think about it, when I was growing up, I felt like trusts were for rich people, right? Rich people had trust, but that's not the case. And I know we also help people administer trust. A lot of folks will create a trust and not have a son or a daughter or a spouse who can run the trust, administer the trust. So we will do that a lot for folks too. But I was going to ask you, Cassandra, in this public versus private discussion that we're having, if you're passed away and your heirs have to go open an estate for you, whether there's a will or not, so they have to just do some estate administration, what kind of information is public at that point?
So estate administration files, the entire file is public. So some of the counties have e-filing now. So a lot of this is also available. Just click the button on anyone's browser. So your heirs, whoever your heirs are through intestacy, their ages, their addresses, what your assets are, and the exact value of each asset, what your debts are, the claims against the estate. So it's a lot of information that's public. Even down to the bank account statements, the account numbers are redacted, and on the online filings, you can't pull those bank statements, but in the physical file, which is public, those are accessible as well. So
yeah, there's a lot out there. I saw, I'm a big wrestling fan, but somebody wrote a book. Somebody wrote a book about Ric Flair. And it was supposed to be like a biography of Ric Flair, and they did it everything was just based on files they could pull in the Mecklenburg County courthouse. So yeah, any estate that he was a beneficiary of, divorces, guardianships, any kind of civil lawsuit, it's all public record. And the guy wrote an entire book just based on what he could get off the public record. So it's
yeah, definitely. And then, so I'm happy to keep talking about what's public or not public, but I'd also like to jump back to your example of a 42-year-old man who's passed unexpectedly with some debts. There are some tools at our disposal or at anyone's disposal in filing estate administrations if the person has a spouse or children under 18. There are ways to protect a spouse or minor children from creditors up to a certain extent. So it depends on what assets exist, what debts exist. But through a spousal allowance, a spouse can be assigned the first $60,000. Currently, it's $60,000 of personal property, and that's able to be protected from most types of creditors. There are certain types of creditors, such as medical creditors, that can get at a spouse regardless of a spousal allowance being filed. So there are certain types of debts that a spouse takes on no matter what, essentially.
No, it's, and again, if all this property was in trust, if all this property was positioned in such a way where it did not become an asset of an estate, that really helps. It really helps in everything that we've been talking about. It really helps keep it, your heirs are going to move easy. Your family is going to just move, it's a tough situation, but they'll be able to continue on without the angst of having to deal with what you deal with every day.
Yeah, we're here to deal with that angst for you. But that is something, even for my clients, that they know their estate administration is happening. It's not completely out of their minds, unfortunately, until it's closed. And some of the clerks and courts run a ways behind. Some of this can take a while, even with good attorneys in your corner helping you through the process. So we're here to help, but to be able to impossible.
Well, Cassandra, it was good to talk to you today. I always appreciate you joining us and giving.
Thank you.
Cassandra Nicholas, fellow attorney at Whitaker and Hamer Law Firm, joining us on the program. Estate administration, again, talking about the different levels of law there. Josh Whitaker and Joe Hamer are your managing partners at Whitaker and Hamer Law Firm. And of course, they are the hosts of this show, and the power behind the program is Whitaker and Hamer Law Firm. We are going to take a short break, come back on the other side, and wrap this up. Now, if you've got a legal situation that you're facing, remember, you can always call Whitaker and Hamer. They've got offices conveniently located for you in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, Gastonia, and in Morehead City, where you can find Cassandra Nicholas. The number to call is 800-659-1186. That's 800-659-1186. Leave your contact information and briefly what the call's about, and an attorney will return that call from Whitaker and Hamer. And you can always email your questions to the show, info@judicacounty.com. That's info@judicacounty.com, and we will answer those questions on a future broadcast. We'll wrap up more Judica County coming up.